Hello, I'm Jodi Brenner Ginsberg of Ginsberg Law Offices. Today I want to speak with you a little bit about what's called a Medicare Set Aside when you settle a workers' compensation case. They are typically referred to as M.S.As, so I'll refer to them as an M.S.A. What we have in an M.S.A. is a situation where currently, as the Medicare guidelines require us to do in a settlement, in certain situations, and again, you must consult your lawyer to determine whether or not you need to have an M.S.A. in your case, but in certain situations, what we are finding out from the Medicare or CMS, Centers for Medicare Services, is that they do not want the burden of paying for a workers' compensation injury. Meaning, you cannot just settle your workers' compensation case in certain cases and then turn around and apply for Social Security disability, thereby getting onto Medicare and having Medicare take over the responsibility of your workers' compensation injury. Now, it is not applicable in every single case. There are certain threshold guidelines that CMS requires us to have an M.S.A. or some way of dealing with the medical aspects of the future costs of your medical care down the road. So let's say you settle your workers' compensation case and you have simply just applied for Social Security disability, not even gotten onto Social Security disability, or settled your case for, at this current time, a $250,000 amount. In either of those cases, Medicare will require us to get an M.S.A., and that is a third-party company who is hired to go out and accumulate all of your medical records and your prescription drug information, and then do a projection about what it will cost into the future to take care of you medically. In the two situations where a person has simply applied for Social Security disability or is going to settle their workers' compensation case for over $250,000, there is a threshold requirement that a Medicare Set Aside should be done. However, it doesn't necessarily have to be done because there are other ways to deal with the medical. You could potentially, in those situations, settle your case in a lump sum amount and then leave the medical open under workers' compensation. And again, that is part of the negotiation that we have with the workers' compensation insurance company. The other way that you also can deal with the medical is to say a portion of the lump sum settlement, without doing an M.S.A. per se, is going to be placed in the settlement, and that portion of a lump sum might be utilized to simply say that must be used for your medical care. So there's a lot of discussion about what is required by CMS in terms of an M.S.A. Every attorney who is practicing in this area has been dealing with these issues for the last several years or should be dealing with them. In our office, we deal with them a great deal, and we are happy to advise you on whether you need an M.S.A., whether leaving medical open might be an option, or a portion of your lump sum settlement that can be stated in the settlement documents that might cover a future period of open medical. The point is, it's a rather complicated area, and it is not advisable to get into settlement discussions without having the advice of counsel. If you'd like to speak with me more about this very complex area, please give me a call at 770-351-0801. Thank you.